Hello, I'm Jessica Ryan Keeney. I'm an attorney licensed to practice law in California. I'm the Department of Child Support Services attorney for two small Northern California counties. What I'm about to say today is not legal advice. Go ahead, like our video, subscribe, ding the bell so that you get notifications when we upload new content. And if you have any questions, put them in the comments below. The answers will not be legal advice, but they always make for great discussions, and sometimes they make for topics for new videos. So today we're going to discuss administrative orders for genetic testing from DCSS. So what is an administrative order for genetic testing from DCSS? It's an order issued by DCSS, also known as the Department of Child Support Services, and not a court, ordering a party to take part in genetic or DNA testing to determine if a person is the father of a particular child. This order is often issued at the beginning of a child support case when the parties cannot agree if the man is the father of the child. Some counties may issue an administrative order for genetic testing before the court case is even opened, and others may issue it after a court case has opened. Some counties may do either. It may be issued requiring the alleged father to participate in genetic testing, or it may be issued requiring a parent that has custody of the child to participate in genetic testing with the child. If a party does not participate in genetic testing after being served with the administrative order for genetic testing, then DCSS will just get a court order ordering them to participate in genetic testing. If a party still does not participate in genetic testing, and that party is the alleged father, then an order may be made making the alleged father the father of the child regardless of genetic relations. And if the alleged father or the parent with custody of the child doesn't participate in the genetic testing after a court order is issued, then the party may be held in contempt of court, which could include jail time. So what's the law for these administrative orders? Well, Family Code Section 7558 states in relevant part, this section applies only to cases where support enforcement services are being provided by the local child support agency pursuant to Section 17400. In any civil action or proceeding in which parentage is a relevant fact and in which the issue of parentage is contested, the local child support agency may issue an administrative order requiring the mother, child, and the alleged father to submit to genetic testing if any of the following conditions exist. Not all of the following, if any of the following. 1. The person alleging parentage has signed a statement under penalty of perjury that sets forth facts that establish a reasonable possibility that the person is the child's genetic parent. 2. The person denying parentage has signed a statement under penalty of perjury that sets forth facts that establish a reasonable possibility that the person is not the genetic parent of the child. 3. The alleged father has filed an answer in the action or proceeding in which parentage is a relevant fact and has requested that genetic testing be performed. 4. A woman who gave birth to the child and the alleged father agree in writing to submit to genetic testing. So there you go. That's an administrative order on genetic testing from DCSS. DCSS is also known as the local child support agency. Thank you for tuning in. If you have any questions, put them in the comments. The answers will not be legal advice, but again, they make for good conversations. And go ahead, like the video, subscribe, ding the bell so that you get notifications when we upload future content. And if you have any other child support related comments, put those in the comments as well. Thank you.